I call the meeting to order tonight, and join me in a salute to the flag. Spinning around.
That's me. I did do that. Yes.
All right. This meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, the Sunshine Law. Notice of the 2026 annual meeting schedule has been provided to the officially designated newspapers, the Township Clerk, posted on the Township website, and available at the Hillsborough Township Municipal Complex. Meeting and application documents and plans have been made available on the Township's website at least 10 days in advance of this meeting. Complete application files are available in the Planning and Zoning Department for inspection in accordance with the public meeting notice. Can I get a roll call of the members and professionals?
Mr. Sirachi is absent. Mr. Deb absent. Mr. Smith absent. Mr. Wagner.
Here.
Mr. Flagg.
Here.
Mr. Radowitz.
Here.
Mr. Vitale. Absent. Mr. Lapani.
Present.
Mayor Payne.
Here.
Vice Chairman Peason.
Present.
Chairman Ciccarelli.
Here.
Mr. Boyce.
Present.
Oh, Mr. Brewster's not here.
Mr. Heck.
Mr. Hack.
Yes.
Mr. Mayhew. Here. Mr. Callis.
He's in the back.
Oh, okay.
The man behind the curtain.
And I'm here.
All right, well, thank you. All right, consideration of meeting minutes, we have none. Consideration of resolutions, same. Planning board business, none. Business from the floor for matters not on the agenda. So open it up to anybody here for anything that's not on tonight's agenda. Yeah, you want? Oh, yeah, okay.
Yeah,
Is it on?
My name's Ken Baker, 452 Farm Road, Hillsborough. Just for clarification, is this the time we should consider asking or suggesting things about the development?
For tonight's application?
Yes.
No, it'll be
No.
after they present what they're going to talk about, and then,
Yeah, I just wanted clarification when it happens.
okay.
So you'll let us know?
Yeah,
Great.
absolutely.
Thank you.
You bet. Okay, that's all the business. Consideration of ordinances, none. So, tonight's application, public hearing, Sukdev and Ruchika Ongris, file 21-PB-13-MSV, 2025 EXT-RES request, I guess extension resolution request. This is TOD 33126 with an extension, Block 152, Lot 3, Farm Road. Applicants are seeking a one-year extension of time for the filing of a preliminary and final major subdivision with C-bulk variance and waivers from December 10th, 2023 through December 10th, 2024. A one-year extension of time from December 10th, 2024 through December 10th, 2025, and a one-year extension from the time of December 10th, 2025 through December 10th, 2026, and requesting to amend the condition of approval number 18 contained in the resolution dated December 9th, 2021, on the property located in the R residential zone. This has been adjourned from January 8th, 2026 without further notice. So, council?
Ladies, Mayor and gentlemen, Mr. David Bouillon. For the record, Jim Stahl, S-T-A-H-L. The firm is Boris Golden Foley, Vignolo, Hyman and Stahl in North Brunswick. I've been privileged to be here before, and on this application, I'm sort of feeling guilty making you all come out in a nasty night for one matter, but at least it's not a snow night. But please all be careful. The application is twofold, and again, I don't like to waste time. One of the reasons is an extension through December 2026, and for the 3-year period prior to that. The approval was in 2021. I'm not going to, a lot of things happened back then, whether it was COVID, whether things happened and my client could not get the project going. It is under contract now to a rather reputable developer. I have a contract purchaser representative here this evening, if necessary, but I don't BS. It is what it is. I'm not going to bring up and try and fabricate reasons. It just could not get started for a number of reasons, and we're asking for an extension. That's number one. Number two is a correction in the resolution. Now, again, it was a mistake. I'm not blaming council, engineering. I usually blame myself, which I guess I could. Maybe I didn't read the resolution properly. Maybe 3 or 4 people that should have on my side, but it wasn't read. And there was this diversion, if you will, in the resolution. We call it paragraph 15 and paragraph 18. Mr. Ford will come up in a minute. I'm going to swear, you'll swear him, and I'll just ask him some questions. I think Mr. Mayhew is the one that may have found it. But anyway, there's 2 paragraphs. Paragraph 15 says unclearly, you're going to give us an easement between the driveway and the lot 3A to the north of the premises in question. A, there is no lot 3A. There's a lot 3.01. B, there's no real room or location to put an easement between a driveway and 3.01, if that was intended. And then, so that's 15, and it's really unclear, and we think it's absolutely erroneous. And then there's 18, which is clear, and it does say you'll give us a 50-foot conservation easement on the easterly boundary of the project, and that we can show, and we can say that was it. We don't know where this easement came between a driveway and the property. And Michael Ford, who you're all familiar with, no one can find it. We just think it was an error in draftsmanship, not criticizing Eric's firm, because I should have picked it up when the resolution came in for review. It happened, and we just want to correct it. If I may, I'd call Mr. Ford, Mr. Chairman, and move on. All right?
Yeah, thank you.
Michael,
Mr. Ford, if you can raise your right hand, please. Do you swear or affirm the testimony you're about to give before this board is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Mr. Chairman, I'm assuming I don't have to qualify the eminent Mr. Ford before this board.
I don't know who you're
Michael,
talking about. Who? No.
Michael Ford, F-O-R-D, licensed professional engineer and planner in the state of New Jersey with Van Cleef Engineering. I've appeared before this board on numerous times.
Yeah, I do know Mr. Ford's reputation. The obligatory, your licenses are all up to date?
Yes.
All right. I think, is it acceptable? So,
And I presented the application in 2021 when the planning board granted approval.
Okay.
And Mr. Stahl has summarized our request. I think the only technicality is the reference between numbers 15 and 18 is inverted. 15 was the finding of fact in the resolution of approval that was adopted by the board that does correctly reference what was discussed during the hearing, which is the addition of a 50-foot conservation easement along the easterly tract boundary of the subject site, and also correctly referenced to the rear of the 2 lots that are at the rear of the proposed subdivision. This is a 3-lot subdivision. And then in the resolution conditions, condition number 18 erroneously references a lot 3A and the conservation easement being along the boundary of Lot 3A. The transcripts, when I search them and read them, there is absolutely no reference to 3A, and the transcripts are on Civic Clerk. But the transcripts do correctly reflect the finding of fact number 15, where I presented to the board the results of our visit to the Environmental Commission, where the Environmental Commission suggested that that 50-foot conservation easement be placed along the rear of the tract, and the lots to our east on Dimitri, and the transcript also accurately reflected the board's deliberation, where the board's attorney summarized the conditions of approval and correctly reflected the testimony that was given, that was reflected in that finding of fact, where the applicant acquiesced to the Environmental Commission's suggestion that the 50-foot conservation easement be placed along the easterly tract boundary. And I'd report to the board that since the board approval, our office has pursued addressing each and every other condition of the approval, all the engineering conditions. And we have a recent review memorandum from the board's engineer dated February 27th, 2026. It highlights the conditions of approval, the items that have been satisfied, which are numerous, and what remains to be satisfied is one description that we need to update because the utility easement servicing the proposed project has been modified slightly at the suggestion of the township engineer, and then also correctly reflects this inability to address condition number 18 in the resolution because A, there is no Lot 3A, and the conservation easement would not fit along our northerly boundary line. And I feel like I've spoken too much already, even though it's not even close to 10 o'clock yet, but that's the substance of it. We've actually secured the outside agency approvals not once, but twice, and in some cases because of the time that has transpired since then. And there was a point in 2022 where Mr. Mayhew's predecessor, Mr. DeSessa, issued to the applicant the bond estimate, which normally is not issued until you have addressed all your conditions, or it's one of those last steps. So it really identifies that the plans are of a place in the approval process such that the quantity estimate for the construction that's necessary can be accurately estimated, and a amount of bond be placed to it such that the applicant then knows just prior to construction, you satisfy placing this bond and the construction inspection fees with the township engineer, and you start construction. But obviously now, because of this typo in the resolution, we're here this evening.
Can you, I'm sorry, can you,
Mr. Chairman, would be that the condition number 18 be deleted as an erroneous insert and with an impossibility, quite frankly. Somewhere, as I said 2 or 3 times, the mistake was made. And you can point at me, or I will never point at Mike Ford, but my office, we have a protocol. So either me and my paralegal that does planning, we missed it. And I think the best way would be to eliminate that condition.
so I'm looking at the resolution and I'm looking at 18, and and it says the applicants have submitted an application to the New Jersey Department of Environmental Protection for freshwater interpretation. So that's why I'm trying to,
Oh, I'm sorry, there's two 18s. There's an 18 finding of fact and an 18 which is a condition of approval. I had the same issue when I was rereading it. You have to go to the end of the resolution to find the
condition of
number
approval.
18.
In
Okay.
page 11,
Okay. All right.
Yeah, he just misspoke in the beginning on what paragraph numbers they are
yeah.
in the findings. But, Mr. Ford, can I just ask
I
you
got
a
it.
question?
I got it.
On the resolution and the conditions, aside from the fact that that you believe that paragraph 18 misrepresents the lot where the conservation buffer is supposed to be, is there any other paragraph that deals with the buffer that's supposed to be at the easterly side of the property?
Yeah, the-
Or is it just 18 appears to have the wrong adjacent lot?
Yeah, the page 4, the finding of fact, I think correctly references the applicants agreeing to provide the 50-foot conservation easement along the easterly tract boundary.
Right, that's on the finding of facts, but that's not on the conditions.
Right, and typically the finding of facts are then accurately reflected in the conditions of approval.
And I understand that,
Yeah.
but council indicated that perhaps number 18 should just be removed. But if 18 is removed, there's also no paragraph there that refers to the buffer on the easterly side from the conditions. So so there's actually two corrections that need to be made if we assume that the existing paragraph 18 is incorrect. Because if we take it out, we still have to add in the buffer on the easterly side of the property.
Correct. Yeah.
Correct.
Okay.
You got two votes
So,
here.
so I have a second question, though. Looking at the site plan, having not been on the board when this application was originally presented, can you tell me, because I can read them when I have the full document in front of me, the paper document, but looking online, can you tell me what the distance is from the driveway line to the northerly property, adjoining property line?
It's about 25 feet.
25.
Correct.
Okay. And on the south side of that, what would be the new lot? I think it's lot, don't mind my squinting. Well, I don't know what lot number it's going to be, but on the south side of the driveway at that spot, what's the total depth of that lot?
3.04.
Well, that's the lot number.
Yeah.
Okay, but hey,
Mark's getting his out.
What?
I'm just asking what the
Yeah.
lot 3.04, the depth of that from what would be the new street, what the depth of that lot is.
About 145 feet.
Okay.
Yeah.
Because I'm just wondering on this topic, I read over the transcript as well, and I will agree with you. I didn't see anything in the transcript that talked about a buffer on the north side of the street. But it would seem to me that with the clerical issue and having necessity to bring this back before the board, perhaps one compromise could be if the entirety of the road just shifts somewhat south to provide additional space between the curbing and the adjoining property owner. So if you said it's about 25 now, and the resolution says 50 feet, the adjoining property owner could have read that resolution and said, oh, okay, so I'm going to get a little extra space. I can live with that. Now they're getting told, hey, as a layperson, this was a mistake and we need to take it out and it's going to go back to 25. But perhaps as a compromise, the whole street can be moved maybe 5, 10 feet over to add additional buffer zone, additional space between the street and the property. Granted, it would take away some area for the lot 3.04, but that's a to-be-built property, so I don't think a subsequent purchaser would be too excited or upset if they lost a few square feet.
Yeah. And I understand what you're suggesting. In 2021, when I presented the application, I think this topic was one of the topics we probably spent a lot of time talking about, and that is how the applicant already tried to develop as part of the design of the project an increased buffer because there was a prior subdivision proposed for this project. Certainly any approvals that went with that have expired, but instead of having a private road, if you will, with shared driveways for the 3 lots, it was a 50-foot right-of-way, and that public road would have been even closer to the northerly tract boundary. The other thing I'd like to point out too is part of our prior application was some variance relief, and one of those items of variance relief was the lot depth of the lot you just referenced, where the required minimum depth per the town code is 150 feet. We shifted everything about 5 feet to make it a little less, so it's at the 145. So one of the aspects of the prior application included relief for that lot depth for lot 3.04. And then just facts. Since the last application, when this error was discovered, in trying to satisfy all the other conditions of approval for the project, including storm drainage details and so on, Mr. Mayhew's office asked us for a supplemental drainage report to prove that the project would not result in any negative stormwater impacts on our neighbors to the north. And it was not just a drainage report for the entire project, but actually a standalone separate supplemental report that dealt specifically with that issue. And in addition to that, Mr. Mayhew's office and his landscape architect specialists dealt with our landscape architect specialists to beef up, if you will, that buffer in that 25 feet that's between the driveway and the northerly tract boundary, where the original resolution, you might be looking at the rendering, and I can pass it out, that was used in 2021, basically had like a street tree soldiering, if you will, of street trees along the driveway, as if the driveway was like a private road or like a public road that would have trees along it, but not a substantial buffer between the driveway and the neighbor. Since then, that landscaping has been substantially enhanced with additional plantings. So, and I know what you're saying. I understand it's really a.
Well, and you answered my next question, because what I'm looking at is just a site plan, and I didn't see that in this current package, the landscape information, so you just provided it. So it's
Yeah.
going to be, so there's going to be plantings along that property line.
Correct.
Okay. All right, that's all, the only question I have for now. I may have more.
Part of the application is stormwater management. There's the road, if you will, along that property line is going to intercept all the runoff that naturally goes from our property traversing in a northerly direction toward our neighbor, intercepts that. Unlike a lot of residential private driveways, especially one as long as this one is going to have curb along it, so it ensures that the runoff is captured and directed to the on-site stormwater management facility. The on-site stormwater management facility not only includes an underground small-scale subsurface infiltration basin. That's the technical phrase. It's referenced in the NJAC 7:8. But it also includes, and that's for quantity control, it also includes water quality measures with MTDs that provide for treatment of the stormwater runoff from the motor vehicle surfaces.
Okay. Normally, do we go professionals and then Deus, or does it see if, I mean, does, so, yeah, Mr. Mayor, do you have any questions? Does that conclude?
Yes, sir.
Mr.
Yeah,
Ford's
and
testimony?
in addition to the amendment of the resolution, certainly you can add a condition that we would comply with the Pannoni, Mr. Mayhew's review memorandum that I referenced just a moment ago, dated February 27th, 2026, because it includes the request for that supplemental landscape along that northerly track boundary, which was not on the original plan nor in the resolution of approval. But we've already added it to the plans, and we're not taking it back. And I think, you know, in discussions with your board engineer to protect the board that stays as has been presented by the applicant, that would be provided for by making the compliance, if you will. The original board approval referenced the memos that were existing at that time in 2021 from the board engineer. Since then, now we have a February 2026 review memorandum, and we are agreeing as any amended condition of approval this board may grant to satisfy that memo as well. The few remaining conditions that are in there.
Mr. Mayhew, you have any?
Thank you, Mr.
further
Chairman.
witness?
Well, as Mr. Ford has pointed out, first of all, our office does not have any information that would counteract the claims of the applicant's attorney or engineer concerning the northern buffer. And as Mr. Ford's pointed out, there's been two major items that our office has requested and they've provided so far. One of them was a supplemental stormwater management report to identify specifically the runoff heading towards the adjoining northern lot. And their office has provided that report and documented that they are not increasing runoff in the post-developed condition. The second item that our office had asked was to provide a substantial evergreen landscape buffer along the northern property. That was not part of the original condition either. And their office has submitted that. It's in the set of plans that we've been reviewing, and our landscape architect has verbally approved it. So as Mr. Ford mentioned, if there was any approval tonight, we would want to make sure it's conditioned upon our latest review letter. I guess the last thing that I would add, and it's always dangerous to think on the move, but to react to Mr. I forget, Bob, was it you talking to Bruce? Bruce. Mr. Radovich's concern about possibly trying to shift the road over. I don't see an opportunity to decrease the proposed lot 3.04. As Mr. Ford's pointed out, there's a limitation on lot depth. Also, that lot's already proposed at the minimum lot size. So then you would have to move another lot line to maintain a minimum 1 acre. But, and I'll just throw this out for Mr. Ford to think about. The proposed 25-foot wide shared drive already exceeds RSIS standards. It's not going to be a public road. Maybe there's an opportunity to decrease the width a little bit. It's curbed, so I would have normally thrown out a number like 18 feet wide for a 3-lot subdivision that's going to share a driveway. 18 would be sufficient, but when you introduce curbs, that makes 18 feet feel tight. So I probably wouldn't recommend less than a 20-foot wide cartway with curbing, or even 21. I know that's only moving the curb maybe 3 or 4 feet over, but if it was the board's, and I would ask Mr. Ford to think about that, because it's dangerous to jump to conclusions, but maybe that's an opportunity to help a little bit. And that's the limit of our comments right now.
Is the road width something that would be entertained? Granted, it's a couple feet.
I'm looking at the applicant or prospective purchaser. From an engineering standpoint, that would, it narrows, this would be 2 cars passing each other, but certainly, there's room in 18 feet. One other thought, and I'm getting a chill thinking about it, because he's right. This is dangerous thinking about it on the move like this, but I feel like I do this so often here.
Well,
I can remember being in the audience resketching a whole project.
I wouldn't go less than 20.
Yeah, I was going to say,
'Cause of
maybe
the
the other
curb.
thing we could do too is, instead of soldier straight up curb, we do the angled back,
Laid-back curb.
the laid back curb kind of softens it. So, that would, and it would, we already, are not centering the driveway, if you will, in like the 50-foot space between Lot 304 and the northerly tract boundary. That was part of my testimony at the 2021 hearing, to try to keep the driveway farther away from the northerly tract boundary, so the narrowing of the lot, the driveway could be accomplished just on one side, right? To take all the 4 feet from the north side of the driveway. So there's no magic there either. As far as,
Mr. Mayhew, on the proposed evergreen buffer, since I haven't seen a landscape plan, is it proposed to put it soldering or offset on a berm? What was the proposed evergreen planting?
There's no berm proposed.
Okay.
There's not a lot of room if we, the roadway is higher than the property line. So the proposed edge of the roadway is anywhere from 3 to 5 feet above the northern property. That kind of limits the ability to go uphill with a berm and then back downhill.
I'm just asking,
But-
just since we haven't seen a plan. So what's the number of evergreens that is proposed on the plan?
But it's a double row
Okay.
proposed, and it's our landscape architect is very thorough. She's requested a very nice mix of red cedars, Norway spruce, white pine, American holly. It's a whole mix of, so it's not just going to look like a barren.
That's dense. Okay.
Yes.
in not exact numbers, but it's about 60 trees. I'm just adding up.
Over how many feet? 100 feet, the length of the,
I'm not trying to get in the way of Mr. Ford, as I never do. I mean, you've got a pretty substantial
It's about 250.
landscape buffer, and
well,
Easy
just since
break.
we don't have a plan, I'm just trying to get that out so we understand what's there. We don't have that with us. Okay.
That would be, I think, closer to 300 feet.
300 feet?
Yeah, from the whole northerly tract boundary that we're talking about here is 295.
And it's the whole length that the buffer is being
Correct.
planted? Okay. Thank you.
No, so just to reiterate, I wanted to make clear, our office would not be comfortable doing less than 20 foot wide, but we do support the idea of the laid back curb, I think helps.
Yeah, I think the general preference right now is to keep the 24, the substantial buffering that's being proposed. That's just to provide for more fluid access from, you'll have 3 residents sharing the driveway. That's the applicant's preference.
Is there any thought for emergency access? I know usually the fire department weighs in. Is this exempt from their input on width of cartway?
I don't know the answer to that at this moment after
Okay.
2021.
Yeah, but I think that was based on the 25-foot. So if you're going to go down to 20, I'm assuming that would have to go back for their review and approval or recommendation, I'm assuming?
Right,
Okay.
right, yeah.
Okay, thank you.
Yeah, certainly emergency, we wouldn't want to make a change that was contrary to what the township's fire official would want.
Anything else, Mr. Mayhew? Good?
No, Mr. Chairman.
Thank you. Mr. Coyce, from a planning perspective, what do you have?
Thank you, Mr. Chairman. This is not going to blow your socks off. I have nothing to add to this. I agree with everything that Mr. Mayhew has provided. Just to provide just a little bit of background to this, as we're reviewing for resolution compliance, we're basically at a point that we couldn't go any further because of this provision. And this is partly why the applicant is here asking for this provision. But in terms of anything else, I have nothing else to add. I have no questions for Mr. Ford.
Okay. So for you, I'm trying to remember, were you the planning director at the time that this came through, or was it your predecessor?
It was my predecessor, which also, and for Mr. Mayhew, it was his predecessor.
Right.
So this was challenging in trying to make sure that we understood what was happening.
Right, okay. And, yeah. Yeah. So I'm kind of, I'm assuming everything but what we're here talking about is really okay, right? As far as impervious coverage and all of that, there's no, I would think if you moving the lines and all that would also affect everything else that was accepted
Correct.
3-4 years ago. So, do we have any other comments from the dais? Anybody?
I do. I have a question for Mr. Hack. Did your office have an opportunity to review your file for any notes that council might have had from the time when this original application was reviewed before the resolution was prepared, to know whether or not there was any notes regarding this buffer?
I reviewed I reviewed the file, could not find any notes that would enlighten us on this issue. So, just like everybody else, we took a look at the minutes, the resolution, and really couldn't find anything else that would enlighten us on this.
Fair enough. Thank you.
Anybody else in the dais? No, Sean's got his.
Being that we're adding this buffer, I would like to put some sort of maintenance guarantee or bond on the plants that they'll survive a certain amount of time and or be replaced, since this is a buffer that's being proposed. I don't know if 2 years, something like that. Just so we maintain the buffer for, at least for a chance.
Yeah, the private driveway is shared, and so is the stormwater management facilities, and that would all be controlled by a homeowners association with the 3 lots, so there'd be a mechanism in to even replace them too. So it's not on one property owner's responsibility.
Good. Anybody else? Do I need a motion and a second to open the public?
I'll make the motion.
All's in favor?
Aye.
All right, so now, if the public has any comments for the witness, please come up and ask questions relative to his testimony.
Yeah, hello, my name's Ken Baker, 452 Farm Road. I'm the property to the north of this proposal. And I was here in 2021, and I was also here in 2006.
Stay next to the mic,
Oh, I'm sorry, 2006. I got it.
It's on.
You know, well, I'm real concerned basically about the potential flooding and the storm drainage proposal underground basin. And I was just wondering if there's any other basins like this used in Hillsborough.
Yes.
Are they on flag lots?
They're in all, many different scenarios, residential, commercial.
Okay, and the other question I had was there was additional, I understand, there was additional requirements implemented this year in 2026 on changes to the storm water management system. And I don't know if they've been included. They're more stringent, if I understand correctly, if they're included in the underground basin, or have you considered any of those
This would
new
have,
regulations?
I think what you're referring to is the prior governor in January of this year authorized changes to the state stormwater and flood hazard area rules. But I actually, and this is, this project predates those rules. Obviously, we haven't looked at those rules with regards to this application. And my understanding is that the new governor has actually already put a stay on those rule changes. So my understanding is that those rule changes are not authorized at this point.
Okay, I don't know what's been authorized or not. I just read something to that effect.
Yeah.
And it was because of the environment and I guess additional rainfall that we're getting or anticipated, where this, and I forgot the numbers, but they're significantly, it's to protect, again, it's to protect our environment, and particularly on our street or on my property, since, I forwarded some photographs to David, and he was nice enough to share them with the engineer about the flooding that's going on just from, now there's no impervious surfaces there yet, but just from the runoff that we've experienced from clearing of the land originally back in 2006, there were 488 trees there. That was from your office way back when. And since then, I can't tell you how many trees have been taken down, but I know there's big ruts in that property. And something has happened to the property as it is without any construction that's begun. And my concern is because I have a well and I have a septic system, my concern is that if anything is undersized for any of this or during the construction phase, that my well or my septic system is going to be compromised. And that's a concern I have. And I'm just wondering if the new, if your calculations, your current calculations are such that I know you can't guarantee nothing, but such that, you know, I'm looking for some remediation somehow from either the planning board or engineering to have some guarantee. And I know you can't say this will never happen, but if it does happen, what's going to happen is I have no more septic system. Now I don't know what I'm going to do. I have no idea. Me and my wife are, you know, we're not the youngest people on the block anymore, and to go through that expense would be a real hardship for us. I also wanted to just clarify the buffer, you know, and I appreciate, by the way, you adding additional trees, et cetera, buffers. And I spoke to you briefly before the meeting, and you said you're putting a curb in, and then I just heard some other discussion about you know, an angled curb. And I don't know what the water retention is on an angled curb compared to a straight curb. I have no idea. I'm not an engineer.
It's about a difference of 2 inches.
2 inches.
Yeah, the straight up face curb is 6 inches high, and the laid back curb would effectively make that about a 4-inch high.
So,
And it's really, it would, so, and what, you know, we discussed before the meeting with Mr. Baker, who's kind enough to speak to me about his concerns. And I think one of the aspects of the application that should be a benefit is that the existing runoff from the applicant's property that now runs, you know, in a straight northerly direction through the rear of his property is effectively going to be cut off by that driveway. That driveway is, in essence, like a dam, if you will. It'll intercept that runoff. He's right. The trees right now in that wooded area have a different rate of runoff than the new house on lot 3.04 and the lawn that's there. But again, that same runoff from that area that be developed will be intercepted by that driveway, directed to the underground basin, which is substantial. The analysis we did requires that we reduce the peak runoff rate for the 2 10 and 100-year storm. We didn't just meet the standards where the 80% reduction for the 100-year storm is required, and we're at 79.999. We're substantially below that, and I can cite some numbers for the board if they'd like to hear it this evening. So I think there's been a substantial amount of engineering that's gone into the design to not just meet the standards, but also with eye toward trying to mitigate for even existing conditions where the runoff from this property goes straight through the back of a neighbor's property. And part of the application too includes the extension of public sewer from a point north of this site beyond Mr. Baker's property where the sanitary ends now. So it'll be extended across the front of Mr. Baker's property and then into the site that's being developed. So the public sewer is just past your doorstep now, and now it'll be brought basically to the front of your property. And what I would say too is that having done a lot of septic work in the township, if there was anything that would happen to Mr. Baker's property, he would be required to connect to public sewer. If you have public sewer within 100 feet of your property and you can get there by gravity, you wouldn't replace the septic, you'd connect to public sewer, which I think would be probably the preferred option, but I'm getting too much into engineering here.
Well, what I was going to say was, once construction starts, there's controls for runoff and all of that.
Correct.
And so if there's a problem, call the engineering department, but they'll put silt fence up and they'll control that to prevent any damage to your property. So I think that, you know, that'll happen once it enters the construction phase and it enters the engineering department. So by all means, if anything happens, pick up the phone and call the township.
And also the length of that driveway, you know, and somebody else mentioned the fire laws or whatever, the driveway, it's going to be at least 300 feet long. And I don't know what that means for your fire commissioner here or whatever. I think there's a regulation and nothing's exceeded by more than, if it's 250 feet or more, some other mitigation has to happen. But I guess that's up to your fire marshal here, and they would have that say what to do. By the way, that change in that law, it was 210 and 100-year storm events, and now it's changed to, I believe it's changed to 50, 75, and 80%, which is significant in the way I see this. And for the people that weren't here when this whole thing started, there was a number of variances made, and they were associated with a lot of the impervious surfaces, the size of the lots, frontages, and some manipulation that was done in order to fit the required frontage, I think it's frontage, to fit all these houses in this relatively small piece of property. So I think that's all I have for Mr. Ford. And I don't want to take any more of your time. Thank you.
Thank you. I think you might get another bite at the apple when it's general closing maybe, but do you have anything else for, if there's nobody else from the public, do you have anything else?
No, I-
Oh, wait, there is another,
Yeah.
for the witness?
No, that's,
Oh, okay. So, I guess Mr. Ford is excused at this time? Is that how this works? Motion to close public? Well, I don't know. So, but will there be just closing arguments? Right? We'll still do this. All right.
This may be for Mr. Ford. My wife's questions that she has, they may be part of the testimony.
Yeah, come on up. I mean, if
Mr. Ford, can you take the hot seat again, please?
sorry they got you.
You were excused prematurely.
It is kind of warm up here today.
I thought it was just because I'm Italian.
Some viewers.
Thank you. Hello,
Hi.
my name is Linda Baker, his wife, and I live next door to the lot. And that's adjacent to where our property is. I understand that tonight's discussion, can you hear me?
Yes, ma'am.
Is focused on the 50-foot buffer. However, I need to be clear, this buffer is not just a boundary line to me, it is the only protection between the development and my home, my well, and my natural drainage patterns that already impact my property. As I looked more closely at the impact of this proposed buffer change, it became clear that this is not just a boundary issue. It directly raises drainage, engineering, and environmental concerns that affect my property. Based on what I have already experienced on my land, and I have pictures, so does David, and that includes ponding on my side of my house. When it rains, I get this huge pond that was never there before the tractor came down to do the perk test next door, all the way down and just took away all these enormous trees. So, I am very concerned that reducing or altering this buffer will increase runoff, concentrate water, and potentially introduce contamination risks to my well, which I have in the front yard. Because of that, I need to understand how this proposal complies with New Jersey stormwater and environmental standards. I have some questions. I don't understand how one detention basin is sufficient for 3 homes on this type of L-shaped lot. Like what happens when we have another hurricane or huge torrential rains? Can this one basin take care of that?
So, yeah, Ms. Baker, just hold that spot and let's have him answer the question.
Okay.
Yes. Yeah, that's the way it's been designed. Just for information purposes, the bonding, the improvements that are being installed that I referenced earlier that were in that bonding estimate from 2022 were close to $800,000. So there's substantial, improvements that are being done, and most of that is part of the stormwater management facility. It's a large underground system that promotes groundwater recharge and then also provides for a volume of area where runoff can be temporarily stored and released at a controlled rate. And the other aspect, I think, of this design that would be a safeguard for you, I think that the Bakers being just north of the property is that that the design incorporates that break, if you will, where right now runoff is able to run directly from this site onto the neighbor property and through their backyard, but that fail-safe intercepting of the runoff with the driveway that's curbed and then directs the runoff along the curb down to inlets. There's actually catch basins, if you will, in a 3-lot, single-family residential development. You normally don't see catch basins, like curbside catch basins to intercept ground, the surface runoff. But the reason that that's the case here is that this really has been designed as if it could be a public road. But as I presented back in 2021, the design not only incorporated the substantial drainage elements that would be associated with a public road, it also included a design that's unique in the sense that by being a private road, it takes out of the town's responsibility the maintenance and snow plowing of that road. So it's in essence physically a private road or a public road that's privately owned and maintained. So it's not a simple small residential driveway with a small dry well next to a house.
So it's not a township road?
Correct.
And the person who owns the properties would be the ones to keep everything up?
Correct. And to make sure there's some assurances there, the township has implemented a annual inspection requirement for any stormwater management facility throughout the township. So the homeowners of these 3 lots would be in a homeowners association that would be responsible for that maintenance, but also the reporting of the condition of the stormwater management facility to the township.
Okay. Where exactly will the water go, especially during a heavy rainfall? And how is overflow being handled?
Yeah, there's the basin is on the rear left lot, which is proposed lot 3.02, and the discharge from the basin is at the northerly track boundary of lot 3.02. So that's beyond, if you will, the downgrade of your property.
In that L?
Here, right here. you're here, it's discharging all the way over here.
How will runoff be prevented from being redirected onto my property when I am already experiencing drainage issues?
That, back to the road with the curbing,
That's going to help.
correct.
I can be assured.
That's the way it's been designed. Certainly, you know, we've seen over time that, like people have said, you know, it's a 100-year storm, so why do we have 2 of them in 5 years? But that's not the way it works. It's the percentage chance of it happening within 100 years. And again, I'm going to roll back to the abundance of caution that's built into the stormwater management rules. And in this case, we haven't just met the rules, we've substantially exceeded the rules. And I'll point out a number now for the 100-year storm, so that's the largest storm we're assessing. The basin has been designed to reduce the peak rate of runoff, not by the 80% reduction that's required, but down to 64% of what the pre-existing peak flow is. So you can see it's not just a couple of percent under the 80% threshold, but substantially below that.
Okay. How are groundwater and well protections being addressed in relation to this reduced buffer?
The system, the proposed stormwater management system is got another element that's part of the stormwater rules, which requires a groundwater recharge element standard, so that we can promote recharge of groundwater and supplement it, and not direct all the runoff at grade and not into the ground. So that's an element that we've complied with the design of the stormwater management system.
Okay. And how can this buffer be reduced when it directly serves as the only natural barrier protecting my property?
Well, the buffer hasn't been reduced since what was represented at the planning board meeting in 2021. Part of our presentation was that we preemptively already placed the proposed access to the 3 homes not within the middle of what would have been a 50-foot right-of-way of a public street along the northerly boundary. That was part of that, I think, the 2006 application that Mr. Baker referenced by another applicant and another engineer, and I presented that plan to the board at that time. And when we presented the application in 2021, one of the aspects of that prior application that we made a change to was the shifting of the driveway further away from the property line to provide greater separation to the northerly boundary, and again, making it a private road rather than a public road that wouldn't, require township maintenance.
If you can answer me this is for the record. I don't understand why you can casually walk back on a condition that was already approved by simply calling it a mistake, unless they were formally amended through proper procedure. New Jersey planning boards are governed by the municipal land use law.
I will try to answer that. Number one, there was no casual change. There was an obvious mistake in the drafting of that one provision. There was no, and could not be, because of impossibility, the easement which was suggested with regard to adjacent to your property. There was no Lot 3A, there was no room to do it. What was there is a conservation easement. This is not pursuant to the MLUL, an amendment to the application. It is a correction of a mistake. It has no impact or bearing, as indicated by Mr. Ford, on any drainage, either existing or proposed in the future. And if I may, all of this was something, but I respect you and your husband, was items which were discussed in detail in 2021. So there has been no, and I'll ask Mr. Ford, there has been no change, whether material or immaterial, with respect to this application since 21 to the present. I'll ask Mr., I'm trying to help, not obstruct. Michael, to your knowledge, has there been any change in the conditions of the property of the applicant or any well, no, just this, because you don't know surrounding, that has changed the decisions and testimony you gave in 2021?
Yeah, no, and what we're discussing this evening, what we presented and what I think the board thought they were formally approving back in 2021 hasn't changed. We're not changing anything.
But it was on,
Here, let me say it another way
it
is
was
to.
approved that way.
Well, let me describe it another way. If the actual condition that the board thought that they were granting was included a 50-foot conservation easement along the track boundary that we're describing, the entire driveway would have been within that conservation easement. So I think what the board's action would have been, if they really wanted a 50-foot conservation easement at that location, would have been to not act on the application and send us out to redesign the project, because it would have been a complete redesign. I think what was factually represented at the board meeting that evening, and Mr. Julian was one of the members at that time, and he was, I think, the chairman of the Environmental Commission, and we had just visited the Environmental Commission prior to the public hearing at the Planning Board. And during our presentation at the Environmental Commission, they suggested that we add this 50-foot easement along the rear of the two rear lots, and that is coincident with our easterly tract boundary. And the applicant was willing to provide that, even though there's no code requirement or ordinance that requires a buffer between a residential use and another residential use that would have been applied to ask for that 50-foot buffer.
Well, intent doesn't override what was approved on record, and I'd like that on record. After clearing the trees, when you had to do the perk test, this increased in impervious and disturbed surface runoff. Runoff increases significantly, soil impacts, water moves faster. This is what happened. Again, I have in my front yard, I have a marsh in the left part of my front yard. I have a stream. I have a big front yard running down. I have pictures on my phone. David has pictures.
But how is that caused or created by this property?
Well, I'll
which is
tell you
not-
why.
No, I'm trying to, I understand, and I'm being polite, and I just asked you to reciprocate. The question I have, and I'm not fighting
Yeah,
with you,
you didn't
is
say right.
tell the board how since 2021, with the exception of a machine that came down there once, how did this create a condition on your property?
Oh, that's very, very easy to say.
Okay, well, tell us.
Okay, we have this big machine, huge machine coming down and knocking down these trees that are way up there. This round, we've never had this before in our yard. We've been there since 1980. We've never had ponding in our side of our yard. We never had a stream running down our front yard. We never had a marsh in our part of our front yard. This big machine, I don't know what they're called. This big machine comes down and he's plowing down these huge trees. So all the roots are gone. You don't have to be a scientist to understand. When roots are ripped out of the ground, they're dead. The trees are dead. What soaks up the water? Nothing. Nothing soaks up the water. So where does the extra? It's not a sponge anymore.
Let me, are you an engineer, ma'am, please? Are you an engineer by
I don't have to be
training?
an engineer,
No, I just
sir.
want to, please, are you an engineer by training?
I'm a medical technologist.
I understand. Did you engage an engineer to review
My
this?
husband's an engineer.
Okay, did he issue, what kind of an engineer is he?
He's electrical.
Electrical, okay.
I threw myself into research before I came
I
here.
understand that.
I am a researcher. Actually, when I was a med tech, I was in research for Exxon. So I'm a wonderful researcher.
All right, can we move this along? We're not here to rehear the entire application. It does seem that since work has been done on the site, that something has happened. The planning board is not really the place to address that. As I suggested earlier, I would call the engineering department, call the township if there's flooding on your property now due to work on a neighboring site. That,
And that's against New Jersey law too. That's trespassing. It's called trespassing.
again, take that, if you've got an issue, take it up with the township. And
I am, aren't we the township?
we're the planning board. We're here to hear this application, hear this, we're not here to revisit the application. We're here to address this change and this correction.
Change and everything.
Right.
I'm also saying, and you guys you're just like me. You have homes. You love your home. You've been there for so long. You've raised your kids there. Why should I have to live with this? Sir, counsel, are you,
Right.
okay, fine. But I don't think it's fair. It's not fair, and I thought this was all about justice.
So are you trying to say, Ms. Baker, I'm sorry, are you trying to say that the trees were knocked down on your property?
No, up next to us.
Correct. Okay,
The
but that was a
roots are
buffer.
gone.
Right,
The
but that was a
next
buffer
year,
for you.
This is what happened.
And Mr. Ford, from your testimony, you're pretty certain that the new basin, once it's properly installed, would remediate that, it would catch that water before it even gets to her property.
Yeah, I hope so.
Yes. Yeah,
Great.
and there's landscaping that's being planted, so there's substantial tree replacement.
And also the road could be a health hazard to my well, because there's chemicals in what they put, whatever they're gonna put down, and it's not gonna be concrete, it's gonna be asphalt, that'll seep into the ground and into my well.
Well, one of the aspects of the stormwater management system is water quality treatment. I outlined that earlier. So the runoff from the road doesn't just go into the underground basin. Before it does that, it is drained through a water quality measure that treats the water.
I'm all for development. I'm not saying I don't want houses next door. I just don't wanna live in a swamp.
Understood.
Understood. Ms. Baker, before you finish, I know we let you ask a number of questions about the stormwater, which really is part of this, but not really part of what's being asked. What's being asked is for a correction to the resolution that, from my view in reviewing the records, appears to have been a clerical mistake. But I want to ask you something, and I'm going to leave it to Mr. Hack to tell us whether you should be sworn in before I ask you this question, or after I ask you this question, before you answer. You were involved in this from the beginning, going all the way back to 2006 when there was a first application for this property. So you're eminently familiar with the history of this property and what's been going on. The issue today is there's in the resolution a paragraph that talks about a 50-foot buffer. It's separate and apart. There's nothing in the recitals of the factual findings with relationship to that. I've reviewed and read the transcripts from the final hearing. There's nothing in the transcripts that refer to a 50-foot buffer on the northerly portion of the property between the driveway and your property. So you've participated in everything. Do you have any information that you can provide to this board on the question of whether or not a buffer was or was not considered and included properly in the resolution?
It appeared,
It's in the resolution, I understand that, beyond the document, because this to me, unfortunately, as an attorney, this is a scrivener's error. This is somebody made a mistake in the language that they used.
okay.
That's okay. My
all I
question,
can
though,
say-
is beyond that document, do you have any information that you can provide to the board about the inclusion of this type of buffer
All I can say is it appeared.
in the resolution?
I don't know what you mean by that.
In the resolution that was adopted from this application, the document,
You mean
Where
like
it's in.
on the map?
no, the 10 or 15-page resolution that was adopted by the board, that in paragraph 18
Okay.
of the conditions says a 50-foot buffer between Lot 3A. It's in the resolution. My question, though, to you is very factual. You've participated, I'm sure, from what it sounds like, you've come to all the meetings, you've paid attention, you've read the documents, you've participated, you've asked very good questions tonight. I'm sure you did it 5 years ago. But my question to you, to help us as the board to know whether this was in fact a simple mistake, or it was in fact a determination of the board at that time to include the buffer. And my question to you again, because I want to give you every opportunity to tell us,
And
is
again-
whether or not you can tell us whether there was a discussion amongst the board, amongst the witnesses, amongst you, your husband, or anybody else that discussed that day a condition of a buffer
First
between,
meeting I did not attend because I had COVID.
okay, but at
Okay.
any point in time?
So it appeared. That's all I can say is
Okay,
it
so-
appeared to me.
Fair enough. Thank you for the answer.
Thank you.
All right.
Can I go?
Yeah, if you have more questions.
May I add something, Mr. Chairman?
Yes.
When Mr. Ford was talking about some of the changes, we probably missed something that we should have added. When this plan came to our office for resolution compliance, there was a 15-foot utility easement on the north side of the proposed shared driveway. That greatly limited the room for landscaping. Working with our office and our landscape architects, Mr. Ford's office has removed that 15-foot utility easement and placed it on the south side of the shared driveway. It'll run through the front yard of Lot 3.04. That now created 25 feet of unobstructed lawn area on the north side, which their landscape architect, working with our architect, has taken advantage of and filled with landscaping. I see that as a great benefit from where the plan stood 6 months ago. My only ask of Mr. Ford and the applicant is, couldn't we simply add to that now an actual conservation easement to protect the landscaping we're proposing?
Yeah, I know. That's our intent to provide the landscaping there, the conservation easement would ensure that it would stay there in perpetuity.
Right. So, I mean, that's a great improvement from the way these plans looked when they were moving through the approval process.
Yeah.
So really adding this buffer, landscape buffer on the north side of the.
It's significantly
from
wider.
what wasn't there before.
Correct.
It can't go away.
Yes.
Okay,
Thank you.
You're welcome.
all right. Any other comments from the public? I don't think so. Do I have a motion to close?
Second.
All in favor?
I
Aye.
So how do we wrap this up with a, oh, do we have, so close for the witness, do we have closing remark? Or? Last call for, do we get closing from the applicant or from? All right. So for the public, if there are any general comments about this change for tonight, what we're addressing here, the correction, just comments on the correction. Move to reopen. Move to reopen the public. Well, it's just for the witness. So still, move to open for public. Second? All
second.
in favor? Aye. All right, so these are, for the public, your final remarks on tonight's issue. Yep.
I want to thank everybody for your time and really for changing some of the plan. I haven't seen it. I tried to get on the network. I got on the network, but I rolled and I couldn't find any of these new plans. So I guess my final comments again were really to thank the board and everybody participating. And I really appreciate the tree mitigation and the additional buffer. I just wanted to suggest that we continue to have thorough reviews so that, we're meeting any requirements associated with either the township's requirements and/or state requirements. And when I think of that, I think of the fire marshal and the length of the driveway that's going to be there, and whether there's any obstructions from getting fire trucks in and out or emergency vehicles. But I have a request to the board. I'm going to ask the board to require the pre-construction inspection of my septic system and well, and document its current position at the developer's expense. And the reason for that is if it fails under a certain period of time, and it's in good working order now, then I need a liability to insist that the developer be held legally liable for any failure of our well or septic system that may occur during construction and after it's complete. So that's a request from the board. And I don't know if that's typical or not typical, but I really want my concern to be documented so that in the event there is a failure, now everybody knows that we the homeowners do have a concern. That's all. Thank you.
Thank you. Any thoughts on that? Or I know wells are sticky, and it's up to the homeowners to maintain and monitor their wells. So I don't,
Wells fail for all sorts of reasons, hard to die, especially
septic.
how old it is, And so there's no any presence of doing any sort of inspection of a well or guarantee of
yeah,
that.
I don't think we can impose that on the developer, but you're on record is stating it here, and should anything change, I would suggest you come to the township. If anything goes wrong, we're not, the planning board doesn't address that. We're not the township committee, we're not the administration. If something does happen, call the township, absolutely. I think so do I have to move to close again? Motion to close public?
So moved.
Second? Yeah. All in favor?
Aye.
All right. I think when I, do you want to make any closing
No,
statements?
I think we've discussed it, and I think the board knows what relief we're requesting.
I think in summary, when this all gets all boiled down, basically, we need resolution number 15 to match condition number 18. That's it. Because condition 18 is the 50-foot easement on the, and that's it. So, right?
Right. The one needs to, it either just needs to be
It needs to match.
changed, or it needs to be removed and replaced with the 50-foot easement.
Well, that's what I'm
on the
saying.
on the eastern side of
By
the property.
making the resolution number 15 match condition number
Right.
18, or vice versa, which
Right.
is the 50-foot easement, that's all we really need to happen.
And-
I think that's it. And then everything else has been a bonus and an add to the development, the buffer, and the things that were discussed, the Pannoni memo. I think that's all
Mr. Chairman,
benefit.
and I know the council does an excellent job. I just to define it for the purposes of a resolution, we're talking about the eastern property boundary to be the 50-foot, quote, conservation, end quote, easement along those two pieces of property.
Right.
Got it?
Well, there was also a discussion just a minute ago about the 25-foot section north of the driveway.
Yes.
Along the length of the 250 or 290 feet, that was also going to be considered a conservation easement along the property. So that's going to be added as an additional condition for the site.
And
That-
your suggestion of about 20 feet probably is a good number, because the curb line is 25 feet from the northerly tract boundary. So that gives a little land beyond the curb line to assure someone doesn't say you can't maintain their driveway or so on and so
Mr. Mayhew, would you agree with that?
but you still preserve the trees that are within that buffer between the,
Yeah, I think a 5-foot safety zone to provide future maintenance of the curb is adequate. So that would leave you 20 foot wide.
Yeah.
And then that easement goes all the way up to the Baker's property.
correct. 295 feet,
Well, exactly.
and the extension of the approval.
I don't know whether the board wants to consider two separate, or did you want it all in one resolution? It's up to you. I have no preference.
I think it's easier to have in one resolution. One resolution.
So, Mr. Hack, you want to can you summarize, or we talked about a lot, all the conditions tonight?
Yeah, so what's being considered by the board is a correction of the resolution, specifically condition number 18. Additional conditions of approval are going to be compliance with the Mr. Mayhew's review memorandum of February 27th, 2026. And the additional, and I'm looking for the verbiage for the additional conservation easement on the, what do we say, northern side.
adjacent to lot 3.01.
Yes. There you have it.
So.
And the plantings as described with the bond 2-year warranty or guarantee
Was that the Panoni, the warrant,
on the plantings.
And isn't also just getting a reconfirmation from the fire marshal that the reduction in street size from 25, we're not reducing
No,
the street?
it's going to stay the same, I thought, the street.
the 20-foot we talked about was the easement.
Right, no, I
Not-
thought,
not the
I
road.
thought the original street size was 25 feet, and
Yeah.
we're reducing it to 20. No? Okay.
No,
Then I take that back.
Maybe I could suggest that the additional 20-foot easement not be characterized as a conservation easement, because usually that's something that protects an undisturbed area. In this case, it's a landscape buffer easement, if you will, to guarantee that once the construction's completed and the plants are in there, because that area is being disturbed in the sense that there's some regrading in there. Just I didn't want to have some confusion and be back in 5 years.
So we're going to
After
call it
spending-
a landscape buffer easement.
Correct.
So if that's, I'm going to develop that resolution. I need a motion and a second to approve.
So moved.
I'll second.
Any- Motion and second, yeah. Any final discussion on this? Not roll call?
Mr. Wagner.
Yes.
Mr. Flagg.
Yes.
Mr. Redowitz.
Mr. and Mrs. Baker, I want to thank you for your participation and your questions, and apologize to you for the error that appears to clearly have been made in the resolution. And I think the results of the amended resolution are beneficial to you and your property. And with that, I would say yes.
Mr. Lapani.
I'm going to speak briefly. It's a yes, but I think that the plan is actually better now than it was 5 years ago, whenever it was. So I think that it's benefit to you.
And Mayor Payne.
I'm a yes, and thank you for your commentary and taking the time to come in and talk with us tonight.
Mr. Pearson.
Ditto for everybody else. Yes. Thank you.
And Chairman Chagall.
Yes, and thanks to both the applicant for improving what was here prior, correcting this error, and to the Bakers for, being patient and coming back and showing your interest. And again, if anything happens, call the township at this point, and so.
We'll be cautious. We've been put on notice, and it's always helpful. And I want to thank all of you, and please drive carefully on their way home.
Thank you.
Thank you.
Good job.
All right, thank you. I think I need a motion and a second for an adjournment, and we have a meeting next week, March 12th.
Yeah, yeah.
So a motion and a second to
So
adjourn.
moved.
Second.
All in favor?
Aye.
Aye.
Good night, thank
all.
you.
So it wasn't hard.